to this legal interlude. It's like really our pleasure to welcome you. It's an event like from this newly created but yet like very active like commission, the in-house counsel of the UIA, whose purpose is really like to create bridges between in-house counsel and attorneys by exchanges monthly on practical topics. So for our first legal interlude, the topic will be like practical consideration when companies appoint law firm. It will be therefore the occasion to discuss the criteria that the in-house counsel follow to appoint law firm, the fee arrangement that in-house counsels prefer, and many other topics. So today's event will be divided as such: Q&A session for 20 minutes, and then a freewheeling conversation for 30 minutes. Please feel free to jump in at any time and ask questions. At the same time, I will ask you to please switch off your microphone. I would like to thank our panel for having accepting of being part of this legal adventure, and I will invite them to present themselves. I think we can start first with Arianna, if you may, please. Oh, you're on mute still.
Hi, everyone. I'm Arianna Righi. I'm Associate General Counsel for the EMEA region at Archer Daniels Midland Company, which is a multinational company in the food industry. And I have the pleasure to be president of this in-house commission. Today, I'm a panelist. Yeah, I'm looking forward to the discussion with the other panelists and the audience. Thank you.
Thank you, Arianna. Alina, if you please.
Hello, everyone. My name is Alina QUACH. I'm a French lawyer practicing in China. I'm working there for almost 20 years now. So I will. I'm also a panelist, and I will introduce the Chinese point of view.
Thank you, Alina. Slavomír, please.
Hello, everybody. My name is Slavo Halla. I'm deputy chairman in energy company. We deal in a Central European region and probably more in Europe. Also, I am a lawyer, so hopefully I can bring some perspective to that. And aside, a law professor. Not sure whether that will help today, but maybe we'll see. It's great to see you all.
Thank you, Slavomír. And Rabindra, please. Great honor to have you.
Hi, Rabindra Jhunjhunwala from Mumbai in India. And I'm on the other side of the law. I'm a partner in a law firm.
Thank you very much. So thank you all. And without any further transition, we will start the Q&A session. Slavomír, to start, what are the criteria that you and your company follow to appoint law firm?
Thank you, Alexei. I was thinking quite hard to answer that question. To be honest, we do not have any set of rules which are written in internal directive. I know companies which do have those kind of formats. So maybe Arianna, if then can explain whether that's the case with her group. But in our group, we do not have some rigid points where to look. Of course, and this is not probably surprising to anybody at this call, if we have a good experience with a law firm, either through our project or by recommendation from our other partners in joint ventures or so on, this is, I think, one of the most important points, the referral of good practice. So that's always welcome. Of course, personal connections, either through law faculties or our colleagues from personal experience, that's also definitely one of the pointers. And apart from this, if we have to really find somebody basically out of this common and then basic area, we would probably go to Who is Who or any other kind of legal sort of summary publication for that particular jurisdiction and try to see who is top 5 law firms for that particular area we need. And I think then we would again continue on trying to approach the firms. And again, quite often, or more often than not, it's about personal feeling, how well a rapport can be made with the counsel of the attorney from the law firm, because you'll be probably for various projects dealing with those people on, if not day-to-day basis, then week to week. So you would like to have some kind of personal collection. Of course, this is not the only point, but I think, or at least for me, if a counterparty is somebody who is on the same wave as I am, it's much more easier to explain the business, explain what I need, and that helps a lot. So I think this would be the first thing I would say, and maybe let's talk about different points, and I will also then contribute with other knowledge I have.
Thank you very much. Arianna, do you want to complete on this question?
Yeah, sure. I think what Slavomír says is similar to what we do, but it is true that our company tried to structure the criteria for the choice of law firms. And so for us, what is important when we select law firms to assist us is first of all, the quality of the advice. So the advice, of course, need to be of high quality, very clear, and also short. We don't need long legal opinions because our role is to assist our management in taking decisions. And so we need to explain to them clearly what's the issue and what is the solution that we propose. So that criteria goes along with the requirement that our law firms take a business-oriented approach. Theoretical advice is nice for us to increase our legal culture, but is not what we need. We really need sharp and clear advice from a law firm. So apart from the quality of the advice, for us, what is important is also responsiveness, because our management needs a fast response. And so we would expect the law firms to be able to respond quickly to our request for advice, and especially within the set deadlines. Another important criteria is the cost effectiveness, because the legal spend is part of the budget, and of course, in a company, the finance and controlling teams look into detail how much do we spend, and as a consequence, when we hire a firm, we need to have a visibility on the fees, and we will talk later about the fees arrangements, but for sure, it's important for us to agree with the law firm clear invoicing fees. Since we are a multinational, it's important that the law firm speaks and writes in English, because the members of our teams come from various countries, and the common language is English. And recently, another important criteria for which we ask questions to the law firms is diversity. So we value diversity as a company, and we expect that the law firms that work for us also propose teams assisting us which are diverse, meaning composed of women and men, different ages, coming from ethnic minorities.
Thank you, Arianna. I saw like Rabindra that you were like saying yes, and to the diversity one, definitely. Can you please like explain a bit how it works in India for that?
So when there is a large MNC sending out a RFP, there are sometimes a requirement to be filled up, and diversity is one of them. And another one that I probably touch upon is pro bono practice. Some credit and marks are given to pro bono practice capability as well. So it's not something which is there for the Indian clients as yet, but MNC clients very much seeking out diversity and inclusiveness. And as a firm, we have also put together a team on diversity and inclusiveness. It's a formal initiative within the firm.
Thank you very much. Alina, how does it work for you, like for your law firm in France and in China?
What I hear from the panelists is the criteria for selection are very practical. But from my point of view and from my Chinese practice, what I would like to stress is actually before the practical consideration is rather at another level. What I would like to stress and raise your attention to is in China, there are two main specificities, I would say. The first one is that, and I would quote President Xi Jinping, is that last year, in early December, President Xi has told during a Politburo study session that lawyers in China should consciously follow and embrace the leadership of the Communist Party. We should educate and guide lawyers to consciously abide by the basic requirements of supporting the leadership of the Communist Party and the socialist rule of law in China, and strive to be good lawyers satisfied by the party and the people. So I would let you draw the necessary conclusion of this kind of declaration and what that would entail for Chinese when selecting Chinese lawyers. And I think that what I want to emphasize is that Chinese lawyers and law firms are under a strict scrutiny in China. And I believe that this specificity should be kept in mind when selecting a law firm in China, especially when the case and the scope of activity of the client bears sensitive matters. The second point I would like to raise is that there is no concept of attorney-client privilege in China that is close to what we know in Western countries. In China, there is a general obligation for the lawyer to protect the confidentiality of the information of the client and also the trade secrets. But this obligation is limited. And the lawyer would have, for example, to disclose some information if it entails national security, criminal activities, etc. So I would say that in practice, Chinese law firms, they abide by their obligation of confidentiality, but this obligation is quite limited, and it would not resist, I think, a requirement from a court or from a government to disclose some information. So what I'd like to point out is that China is quite different, and these two aspects should be taken into consideration when selecting a law firm.
Thank you. I think we have a question from Slavomír.
No, I just wanted to add up to what Arianna said, and thank you, Alina. I have to say I'm quite happy that I'm not doing business in China because we tried socialist system in Czechoslovakia for 40 years and it didn't work out. Also with forced, connection of lawyers to the system. But what I wanted to comment on, Arianna mentioning CSR principles or gender or any other kind of diversity. For example, also in our group, we are currently in the process to roll huge ESG policy, which CSR and diversity is part of. So we'll be moving also in these considerations how to approach law firm, basically as any other service provider, with not only the diversity, but maybe also environmental sustainability. Not sure whether, and I'm not even sure how to assess a law firm from that criteria. So I think it will be interesting to have this kind of discussion, attorneys, in-house counsels, what, how, and if this should work. But definitely, I confirm that this is something which we will also be looking much more, because the banks force us. We also would like to do that as well. So this is probably quite interesting whole new field of how to build relationship based on ESG topics.
Thank you, Slavomír. I think now we have Marco.
Thank you very much. I have a question for Arianna and everyone that basically pointed out the diversity, sustainability, environmental issues. I'm a lawyer and the head of innovation for a big Italian firm, kind of 200 plus lawyers. And we have the kind of feeling, so not only me, but all the parties in the firm, that especially with big companies, the high quality, sophisticated legal advice in quick time, reasonable fees and blah, 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 is kind of for granted now. And we are asked about, what do you do in terms of diversity, inclusion, environment? How do you retain younger professionals? Because even retention of young professionals is becoming a factor in the assessment of law firms. So I was wondering, and I would like to ask you, what is now the most important element, and what is the weight you give to sustainability in a wider term, so even beyond the ESG?
Thanks, Marco. I'll go first. It's a very good question. I think all the criteria we mentioned, like quality, responsiveness, cost effectiveness, are still very important. But groups like companies that I work in, we have a strong pressure from the shareholders and other stakeholders, the public opinion, especially groups like mine, whose shares are listed to the New York Stock Exchange, to also introduce among criteria of selection these values. And so I would say it's not a predominant value, but it's one of the criteria that we indeed consider. We need to check the box. And therefore, that's the reason why your firm receive a request to provide evidence on what you do in that respect.
Thank you. I think now we have Rabindra.
I just wanted to add a few more items which I thought should be covered from a lawyer's perspective. What we have seen, one is that the clients are looking at willingness from amongst the law firm to adapt changing ecosystem and to explore technology and innovation. As an example, we had a very large mandate to be done in a very short frame of time, and the client was very willing for us to adapt technology and use some sort of a technology to run through the diligence documents in an automated manner. So that is one thing which I would add. There are two more items. The second is there is great appreciation if the lawyer gets into and understands the business of the client. And third and fourth is sort of connected, where you have shared culture. So there's a firm culture, and that is shared amongst the people in the firm, versus one knows it better than the other. And linked to that is continuity. So if there is a particular client which is very acquisitive or needs regular law firm intervention, they would like to go back to the same lawyer, same partner, same team, rather than explaining the whole culture of the client all over again, because that firm is not able to retain those lawyers. I'll pause there. Thank you.
Thank you, Rabindra. Arianna and Slavomír, do you want to react?
I would 100% sign to what Rabindra said. Yeah, changing team 5 times because it was restructured, and I understand this will happen. But if I can work with somebody I have experience with, and he can also recommend his colleague, because they, yeah, of course they will recommend the colleague from the same law firm. But as Rabindra said, I can expect probably the same culture, same sort of, again, rapport that can be created. They understand the business. I don't have to again and again explain what the underground gas storage is and how it works and all the connections to the group and various problems we are facing. That's great. However, yeah, I would also say, and that is maybe to Marco, we are firstly looking for expertise, even though we are much more now considering ESG, and I understand you cannot probably, well, for law firm, there is only so much you can do in terms of ESG, because you don't have a facility or a plant to do some major overhaul or something. So it's maybe about projects you support or what kind of pro bono activity and diversity, how it works. But first of all, I think we are still looking for excellence and this kind of understanding the business, and not only having legal aid, but also legal aid based on understanding what we need. And this is crucial. Unfortunately, you cannot look for that particular thing in who is who. It's just about experience on person-to-person basis.
Thank you. I think Khaitan, do you have a question as well?
Hi there. So it's a good early morning from the East Coast in the U.S. here. So I have actually 2 comments here. One comment, one question. The first comment is going to the issue about theoretical. I absolutely agree in terms of outside counsel here, and I've served in various capacities outside counsel for a long time here. In terms of communicating the theoretical versus contingency planning here, or sensitivity analysis that's there. So I think at least I feel like, you know, providing value to a client over the years, saying that, okay, I've seen this before. I've seen this several times before, and I understand the question you're asking, but you should be cognizant of, you're asking X, but you should be cognizant of Y, and it's not theoretical here, and making sure that there's value added there, and making sure that we as outside counsel communicate that this isn't us barking up a tree or us padding a bill or trying to just engage in some type of academic exercise here, that is grounded in experience. I guess the second issue is that in terms of diversity, equity, and inclusion, we have a policy in our firm here, but we're struggling because we have both a domestic U.S. domestic practice and an international practice. And so the question is one of standards here, because making sure that we feel like it's, DEI is breathing. We don't need to just have paper. We need to breathe DEI. We need to practice, this each and every day here. But when we're providing, our statements here, it's like, okay, the issue is, are we communicating diversity, equity, inclusion from an American standard, a U.S. standard, or are we looking international? And we tend to go towards the latter because that's the bulk of our practice. But sometimes we want to make sure that we're true to those commitments here, and sometimes that means that we don't quite fit with what is being asked of us, or maybe what's being expected, because we don't want to wave in the wind here. I mean, to have a true policy here, we need to commit to that, and sometimes that means we're not perfect in terms of the fit with the potential client. Because of the difference between, what's a standard here locally or in our domestic market versus what is the standard abroad.
Thank you, Khaitan. And then we have Catherine, please.
Yes, thank you very much. Good morning, afternoon, evening. Thank you for the Commission for organizing this interlude. I'll take the French accent for that. And thank you very much for the panelists for their shares. I have one global comment to make in the name of the UIA, and then I have questions for the 3 questions for the panelists. The global comment is that, as some of you may know, I am the chief editor of French content in charge of the magazine of the UIA called Le Juriste International, and there is a chief editor for the English language as well. And I think it could be great to have like a sum up of the content of this meeting, and in particular like a very practical list of sum up of the criteria that came up from this meeting on, you know, what are the good criteria to select a lawyer, or for the lawyers to be selected. Like basic recommendations or something, or a share or something you would like to write depending on your experience. So please do not hesitate to contact me, and I could liaise with with Stephen Richmond, who is in charge of the and Barbara Gislason. She's chief editor of the magazine. So in relation with the topic of this meeting, I have 3 criteria in mind, and I wonder whether there are criteria for you to select lawyers. And so I would be happy to have your views on that. I will expose the 3 criteria and questions, and then you can answer. So the first one I have in mind is, would you prefer or would you select a law firm offering an internal worldwide network, like, you know, a big law firm having offices everywhere, or would you prefer to select a law firm which is, you know, very well-known, reputed, excellent in a field, and capable to offer contact in other countries if the matter is needs to be handled in several countries? So this is the first question. My second question is, according to you, the criteria would be the same or different depending on the field of law which is at stake? Like, for example, business and criminal matters. And my third and last question is, would be the same or different criteria depending on the size of the law firm? Like, for example, are you considering the level of liability, of insurance liability of the lawyer that is offered by the bar from which the lawyer is depending on? That's it.
Thank you for the question and the idea for the report as well. We will do, of course. Arianna, do you want to start?
Yeah, sure. Catherine, how do we choose between a big law firm having offices worldwide or a small law firm having correspondents in various countries? I would say it really depends on the matter. I work a lot in M&A projects, and so if the project is transnational, we tend to go to law firms which have offices worldwide, so that they can tackle the different local jurisdiction aspects of the deal. We have had experience of selecting a law firm which doesn't have offices worldwide, but can offer a network of correspondents worldwide. The only thing that is important for us in that case is that the law firm we choose, it coordinates with the various correspondents, and it ensures that the standards of quality are the same, because we have a bad and good experiences to go for the second option. And so we really need to make sure that we get the same level of advice if we go with a lower firm, a smaller firm. Then the second question, do the criteria to select law firm differ from the subject matter? I would say no, because understanding of the business of our company, responsiveness, cost effectiveness, quality of the service apply to any kind of law firm. And then I'm not pretty sure I understood your third question. You were mentioning the liability of the lawyers. Can you please clarify?
Well, the question is, and you partially answered to this one through your first answer, is whether you take into consideration the size of the law firm, and the size has a direct impact maybe of the level of insurance liability that is offered by this law firm, depending on the different bars, of course. I'm talking for the French bar, at least.
Yeah, absolutely. And I guess this criteria applies particularly when the law firm advises in litigation. Yeah. Okay. All right.
Thank you.
Thank you.
Arianna. Slavomír, you want to complete as well?
Probably not much to add. We have both experience with big international law firms, as you probably all know which of those. Maybe some of you as well, but also local, not like one attorney, but local names on the market which are established, but they are not international as global companies. And it really depends on what kind of project we need them, if this is really connected only to one jurisdiction. And maybe these also then have to be considered in regards of fee structure or fee basis generally, because local law firms will generally have, let's say, more nice fees for the service provided on still the specialist need we need. So yeah, I think it really goes down what's the size of the project, what specialties we are looking for, and then also is connected to the field of law. Just now we're having a project where we need like experts in 5 different fields of law altogether. And for that, I think from practical point of view, small law firm generally will be harder to get that kind of broad expertise. So generally we are looking more for bigger firms, and I think even international firms, but not because they are international, but generally they tend to have bigger teams with more specialties. So if the subject is complex, the bigger size would probably be a practical matter, because the know-how will be there. And I think this is, yeah, size of the firm, liability as well. Yeah, so it all connects. I think, again, the project or what kind of why we seek the advice really creates the net, what kind of law firm we were looking for.
Thank you. I think if there is no additional question, we'll move to the second main question of this legal interlude. Okay, great. So the second question is, what are the fees arrangement that in-house counsel prefer when they appoint a law firm? Arianna, do you want to start?
Yeah, I can. Just a moment. Yeah, so as I said, we as a company have some pressure from our finance department to keep the external spend under control. And so we need to agree with the law firm, with the law firms we use on clear fees arrangements. I would say my preferred fee arrangement is capped fees. Meaning that we indicate to the law firm what is our need, what are the assumptions under which the fee proposal can be made, and then the law firm should come back to us with capped fees. Sometimes I ask to provide a fee proposal, and the law firm comes with a budget. A budget doesn't mean anything to me, because a budget can be exceeded at any time without us knowing. So we really need to agree on the rules of the game since the beginning, and we really like when the law firm respect those rules. When we have a major project, we go for requests for proposals. Rabindra mentioned that. And the request for proposal means that we send out this proposal for assistance to a couple of 2 or 3 law firms normally. And there, in addition to the law firm having to indicate who is the team, whether they have experience in the field or not, there is also a chapter on the cost. And so our main subject there is what is the proposed alternative fees arrangement that the law firm can offer. For, as I said, for an M&A project, this can be capped fees, or for a specific matter like advice on a specific legal question. For litigation, it can be hourly rate with a high discount, and in addition to that, a success fee if the law firm is able to let us win the case. So these are, in a nutshell, the preferred fees arrangement for us.
Thank you, Arianna. Slavomír, do you have any other like arrangement preference?
Well, trying to be funny as low as possible, of course. But I understand that, yeah, there is a work behind that, so it's understandable. Sometimes it's you know, maybe general point, it's hard to explain to managers, not lawyers, that the fees are either hourly or some budgets, because they sometimes tend to be skeptical why and so much they have to pay for lawyers when it's just the paperwork. So I think this is for us in-house counsels to work and explain. I think this is our homework to help attorneys to provide services which are mutually respected. With regards of fees, yeah, I think again for smaller projects we are able even to have not budget but fixed amount, but this is really for small projects where it's basically a template, let's say, something which we repeat many times. Everybody, both attorneys and us, we know what to expect, so we can agree on one fee for all. And of course that would be preferred for everything else, but it doesn't work that way. So yeah, the caps would be the best for us to know that yeah, for this amount. But for example, the project I mentioned with 5 or 6 fields, this will probably take another 2 to 3 years. So it's really, we are still negotiating how to structure the fees, because even we are not really sure how much of legal advice we will need. So then I understand this is basically a matter of contract negotiation, and I think in those instances we would appreciate some reasonableness. Yeah, that's understanding, okay, this is a long-term project, so maybe some discount, and we can work together for 3 years, so it still brings a lot of money to the law office. But most of the time, I don't think attorneys are having troubles understanding a commercial perspective here.
Thank you, Slavomír. I think Suzanne. No.
Yeah, hi. I have a question from the in-house counsel to the law firms in that perspective. How do you, in the law firms, deal and manage these kind of arrangements? Because I understand that Arianna prefers cap fees to budget, but then within your law firm, you still you also want to be profitable, and you still have a budget and timesheets. And how motivated are you to continue working once you have eaten up the fees and there's still work to be done? Or then do you then put junior associates on the project, or is this not relevant because you're thinking long-term relationship? And the same is true for the myth maybe about result-oriented fees and success fees, and management always thinks that lawyers will be more motivated if they have success fees. Personally, I'm not convinced, but what's your view on that from the practicing lawyers?
I'm happy to take a first shot, if that's all right. So I think it's a great comment that you make, Suzanne. I think first and foremost, what we need to do is have a constant dialogue and an engagement with the in-house counsel. I think they will appreciate if work has been put in and then fees are being charged. What they will not appreciate is you're going over budget for no reason, or something which you had not initially thought of. We constantly review our timesheets, our efficiency. The finance team does it along with the partners, and where we feel that we are spending far more time and it's not profitable, we will do an internal review, and where needed, we will engage with the client. And again, if it is a relationship client, they'll understand it better, easier, versus a new client. Success fee model in some countries are not allowed. In India, we don't, that's regulatory not allowed. So of course we cannot have that. But capped fee, lump sum fee are some models which are very much in vogue. Of course, as a lawyer, we'd like to work on an hourly basis, but even when we are working on an hourly basis, it is supported by very well-defined timesheet, which if somebody reviews, it'll be very clear. You know, it won't be timesheet which has been padded up, or timesheet which has discrepancies in it. Two other points. One is regular updates to client and regular billing. So we would like to do billing on a monthly basis and probably send a regular update. It could be a weekly update, it could be bi-weekly, or whatever frequency the client chooses, but regular billing, not bill at the end of the year. Some firms tend to bill at the end of the year, and that is when a whole debate sort of starts about the value which was provided. So these were some of the comments from a lawyer's, from a firm's perspective.
Thank you. Alina, do you want to complete as well?
Yes, I would totally agree with Rabindra's comments. On my side, I would say that we try, of course, to address the client's budget needs. But what I would say is that in China, both from corporate point of view, but also from litigation point of view, many unforeseen matters would impact the volume of work. So it is quite difficult for us, for example, registering a company, although now in China it's become more standardized, but registering a company or negotiating a joint venture, you have to negotiate with the counterpart, but you also have to negotiate with the administration. For the litigation files, it's very, very time consuming. So most of the time, we will not propose therapy for litigation because it's really difficult for us. For corporate matters, it would be a cap fee, but if every time we put in our service agreements that if there is any difficulty, unusual difficulty arising during the handling the case, we would rediscuss with the client the fee level.
Thank you. And generally speaking, Alina, do you see like a difference between like what your French customers and what your like Chinese customer ask you in terms of fee arrangements?
You are talking about the fees? Yes. Chinese customers are very demanding. They want very, very low fees with immediate results. So it's very difficult to discuss with them. And most of the time we will require payment in advance because I would say that we encounter more difficulties to recover our fees with Chinese clients than French.
Thank you.
Just
May I ask a question?
Sure.
If you want to continue on this topic, please. I have another question actually for the in-house lawyers.
Oh, please do so, please.
Okay. Arianna, you were saying that at the beginning of this webinar that you want straightforward advices, no long legal opinion. What I can see in my practice is with the big companies is that they have to be backed by law firms, have a document to justify their position. And sometimes some of our clients, they would request actually very formal legal opinions just to back them. Do you have the same concern, Slavomír and Arianna?
Yeah, thanks for raising the question, Alina. Listen, no, we prefer not to have long legal opinions. We don't have the time to read them, by the way, because we are dealing with so many matters that although we would love to know everything about the background of jurisprudence or legal provisions, we don't have the time to do that. So we really need the law firm to provide a short advice. Just to give you an example, as I said, I'm doing a lot of M&A. So when a law firm is assisting us in the due diligence, I tend to read first of all the executive summary, and if I have time, I read all the 150 pages of the rest of the due diligence. And what we see is that law firms that are used to us, they even start to draft this shorter due diligence reports because they know that we will not read those. And actually, for us, it's very important the trust that we have in the law firm. So we know that they have done all the researches, that they've seen all the risks, and they only highlight to us what is important because we have explained beforehand to them what is that the business needs from us and what they need to focus on. All these comments and that we are exchanging here make me think that what is important here is the trust the relationship between the in-house counsel and the law firm. And know each other is key here. So the law firm knowing what the business is, what are our constraints, and us explaining to them what we expect in terms of legal advice is really key for a very good and long-lasting relationship between in-house counsel and the law firms. What do you think, Slavomír?
Yeah, I remember up till today a wonderful 15-page memorandum from a big company specialized on a field, which basically I needed only one page. The rest was summaries and what ifs and sort of a lot of legal talk, sometimes with a lot of disclaimers, which I did not even forward it to the memo to the directors because they would probably eat me alive, that it was not really sure what was the answer. maybe only for a lawyer. So, and we paid a lot of money for that. So yeah, I think, and again, it goes back and boils down to building a relationship both for us and as in-house counsel. We need to communicate clearly to the attorney what we really are looking for. If we are looking for academic work with a lot of jurisprudence included, because for some reason we need it that way, we should probably say it very clearly. But I think most of the time we are relying that the law firm knows the law, knows the jurisprudence, and they give us the main big results, especially in complicated matters. Yeah, so yeah, if I have time, I read the memos completely, because especially with foreign law, it's interesting for me to learn about, but that's only if you have time, and that's not many of days when you can do that. So yeah, executive summary, straight answers, and before providing any kind of draft, just to maybe confirm with the client that the law firm understands not only what is the questions, but the background, why we are asking that question, and that really shapes what's the structure of the memo, I think. But this will not, of course, yeah, probably it's not easy to do that if this is the first time relationship between the client and the law firm, and it will probably come with later development and more relationship being built. But I think at least trying from the very beginning shows a good sign for client to be engaged with that law firm for much more than just one-time opportunity.
Thank you, Slavomír. I think we have a question from Rabindra.
Actually, more in the form of a comment. Many in-house counsels now are moving away from being in a law firm for a variety of reasons. And I think from my practice, I see a big difference in interacting and engaging with somebody who has spent time in a law firm versus who has always been in an in-house role. Because a lawyer from a law firm going into an in-house role probably understands the law firm's perspective on billing and engagement slightly better. So just a comment from my side.
Thank you. Then we have Jeremy.
Yes, thank you. Just a quick question for the in-house lawyers. I was wondering if you would conduct some kind of assessment when the mission or the litigation is over. Do you do a review of what happened and does that kind of review unlike the future choice of lawyers if you continue with that lawyer or if you need to change?
Arianna, yeah.
Yes, hi, Jeremy. That's a very good question. And yes, we do. We do such a review. And the review is based really on the same criteria that leads us to select the law firm. So after the project is ended, we have a questionnaire that we fill in. And we respond to questions as the law firm being responsive, what was the quality, did they understand the business of our company, were they cost effective, what is how would you rate the law firm from a diversity perspective? And really there are points, like when you receive a customer appreciation questionnaire from 0 to 10, and then you click, 5, 10. And all this goes to our global legal operations, and it let us either confirm that we are happy with the law firm and we want to continue, or to decide not to use that law firm anymore, which I assure you is very rare.
We have, I think, quite similar system. Maybe the only difference is that we are not evaluating after the end of project, but as a general system for all suppliers, we are doing the evaluation on a yearly basis. So basically at the beginning of the year, evaluating the work of the supplier for the whole previous year. If there are more projects, so then it's more average of those points. But I think this is just a matter of what's more suitable methodology for one or the other company, but basically the same considerations.
It's very interesting, because sometimes the criteria you put it like they are very objective. If the lawyer can respond quickly, he has a 5 on the 5, for example, things like that. But sometimes it can be more tricky to put a mark on a information value. You know, the capacity of resolving an issue or a problem. And I'm guessing sometimes can be tricky, or can be a struggle to put a mark on that. And for example, when you have like a litigation, that the amount of fees is put in perspective of the amount of money you can obtain from the court. Do you do some kind of okay, it cost me that kind of money, and I obtain from the court that kind of money, and then you can compare and how I can say enlighten again that assessment with that kind of information. Is that something that is done?
Absolutely. And this is part of the cost effectiveness evaluation, right? So if, for example, the law firm helps us to win a case, even though the fees are high, we need to pay those fees, because in the end, the law firm helped us to recover even more. So yeah, the answer is yes.
Thank you.
Unfortunately, I'm lucky enough not to be involved in any litigation for past 10 years, and the same for the rest of our part of the group. So I cannot provide better approach to that than Arianna said.
Thank you. I think now, and we will close the speaker list, we'll have like Giovanni for the last question.
Yes, thank you very much. I have a question. Once you have selected a law firm, a lawyer, maybe you work in long run with this lawyer, I have this kind of question. These lawyers, these external lawyers, what kind of relation you implement, and mainly what kind of soft skills you request?
Thank you, Giovanni. It's also a very good question. And with respect to the soft skills, rather than talking about soft skills, what we like receiving from the law firms that we work with is, for example, trainings, legal trainings for our legal team, because unfortunately, not all of us have the time to review the latest laws or the latest jurisprudence. And so a law firm offering us a training on the latest news, I don't know, on a corporate law or new EU legislation in distribution law and so on, for us is really welcome. And actually, we ask the law firms, especially those with whom we work for a long time, whether they are willing to offer this. And recently, I attended some seminars offered by a law firm on the subject matter of diversity and inclusion, for example. So the law firm themselves were offering trainings not on substantive law, but on soft skills. How we can improve our, let's say, diversity and inclusion footprint in the legal team. So yeah, soft skills are welcome.
Maybe I'm not sure whether that's a soft skill, but again, this is more about the relationship. One example I really appreciated when a law firm, which we were involved for quite a long time, they are sending this flash news, of course, with newest updates. But then I received just a specific email saying, "Hi, Slavomír, in Germany, there is new legislation. Maybe it might affect your business. Have a look for the summary we are sending you. Let's discuss if necessary." So it was like, okay, because I'm not a German lawyer and I have not hired those attorneys specifically for this, but they are having this overview, and it clicked in their minds that maybe this is interesting to us, not just a general flash news for everybody, but it was based on that relationship we had, that they understood that, okay, this is specific for this company. However, I understand if you have tens or hundreds of clients, probably this is not something you can do for everybody, but I really appreciated that, and it really improved the connection we have with the law firm. So that was something nice.
Thank you. So, Katrin, you're still on mute.
Thank you, Alexi. And also you say to Giovanni Zagra that it was the last question. So thank you very much for taking this last question. And I'm picking up on Giovanni Zagra's question and Arianna's Righi's answer. And it came to me another question, which is, do you now include in your criteria, at least for a litigation lawyer, a training or education in ADR, alternative dispute resolution, that now the English judges in commercial courts call NDR, negotiated dispute resolution? It's not an alternative anymore.
Thank Katrina, not yet, but why not?
Thank you.
Perfect. Thank you very much. Like the time is already done, so I will briefly conclude. Like, thank you all for joining this first legal interlude of the in-house counsel of the UIA. It was like a pleasure to have you all, and we really hope to see you to the next one. So I wish you the best and have a nice day. Bye.
Bye.
Thank you very much.
Bye-bye.
Bye. Thank you.
Thank you very much. Bye-bye.
Have a
Bye-bye.
good one.
Thank you.
Bye.
Bye-bye. Thank you.